This is a lecture from OpenTuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
We're still in the chapter about killing off companies, liquidations. So this is the second part of that. So administrator appointed by the court. Now, an administrator is not the same as a liquidator. It's not the same as a receiver either. So it's an administrator. And the idea of an administrator is that he's going to try and save the company. A liquidator has got one thing on his mind only, and that is kill the company. That's all his job is. Never mind, but this company could be worth saving. No, a liquidator is there to kill the company. An administrator is there to see, you've got to show the court that it could be worthwhile the effort, but to see if it is worthwhile the effort, to see whether, even though the company is in such financial stress at the moment, they do have this new product which is on the verge of final testing, and it could be a winner, and it could very well be worth keeping the company going. If only we have a little bit more time, and if only the payables, the creditors will just hold off on their claims just a little bit longer. So if we can, if it's worth it, we should save the company. And the reason we should save the company is because I said in the last lecture, nobody wins in a liquidation except the liquidator. The employees have no further wages, no salaries. The directors have got stigma attached to being involved in a liquidated company. The auditors have lost a client. The suppliers have lost a customer. The customers have lost a supplier, have to go and search somewhere else for one. The government is now having to pay redundancy claims and unemployment benefits. The taxman has lost the tax revenues. The VAT man has no longer been able to collect the VAT due on the indirect taxation. Nobody wins. All the people in the vicinity of all these employees, the big employer of the town, has gone liquidated. Think of that, the impact of that on the town and the environment. Think of the mental stress. Think of the local service station, local car dealership, no longer, because people are no longer buying cars. The groceries, everyone except the liquidator will lose. So as a conscious decision, it is worthwhile getting an administrator to look and see if it's worthwhile being able to continue running the company. Or are we able to sell it at a profit? Are we able to sell the company without killing it, sell it as a going concern, because it's worth more as a going concern. And if we can sell it as a going concern, we can still liquidate or just move on, collect the money together and pay off those people that need to be paid off. Application to the court may be by members of ordinary resolution. Remember, it's a special resolution to put the company into voluntary liquidation, ordinary resolution to ask for an administrator to be appointed. So the members or the directors or our creditor can do it. So it's available for interested parties to ask the court for the appointment of an administrator. The court will, if it feels that the company is unable to pay its debts, and the court will, if the order is granted, it's likely to achieve the desired result, which is a more advantageous liquidation, a better distribution, or the recovery of the company, or the actuality of being able to sell the company. The court, but you have to prove to the court that this is going to be a worthwhile exercise, because otherwise all you're doing is lining the pockets of the administrator, because the administrator will be a partner from one of the big four or another accountancy firm. And the effect of an order, a moratorium, all debts are put on hold. You can't chase me now for debts because an administrator has been appointed. And how do you know an administrator has been appointed? Because all people interested are notified. All business letters, invoices, order forms, all documentation leaving those premises will bear the legend administrator appointed or under administration. Powers of management are passed to the administrator. The directors are pushed on one side. They're still directors, but their powers are removed from them. They're shoved on one side, and the administrator takes the reins, and the administrator will drive the company forwards if it's worthwhile doing. Any petition for winding up is dismissed. Somebody has approached the court and said, will you wind the company up? The company's no longer able to pay its debts. No, I'm not going to listen to that one anymore. Just an equitable, not listening to that anymore. Let's drive it forward and see if we can resolve these problems. And then if we can't, then we'll think about liquidating the company. An administrative receiver already in office must step aside. An administrative receiver is a receiver that is appointed by the holders of the debentures that are secured by floating charge. So has control over the assets, pretty much all the assets normally, over the whole of the assets, including goodwill, would be the assets pledged under a floating charge debenture security. Any administrative receiver that has been appointed, step aside, because the court has now appointed an administrator. Duties of the administrator. Now these are pretty much self-explanatory. So what follows now on this page is, maybe I'll add one or two bits, but it's more going to be a podcast. It's reading down the list, but I'll read it with you. He's an agent of the company and the creditors. That's a strange thing, isn't it? That on the one hand, you've got the creditors who put the company into administration. On the other hand, he's an agent of the company. And he's an agent of both, and apparently two conflicting sides. But he's got to do his best for both. He's an independent, honest, fair, decent, qualified insolvency practitioner who's desperately trying to rescue a company. Whereas a liquidator is death. An administrator is like a surgeon. And he'll cut open the body corporate, and he'll take out bits and pieces that are going bad and diseased, and he'll get rid of those, and maybe he'll just sell them. All sorts of people buy all sorts of things, but he'll take the bits out which are causing problems to the company, and then he'll sew up the body corporate and bring it out of anaesthetic and say, away you go, and he'll hand the reins back to the directors if he can. But if in opening the body, he's had to take out all the diseased bones and the lungs and the heart and the kidneys and the spleen and the brain, and there's nothing left, well, there's no point in even sewing it back up. You might as well liquidate it because it's not worth saving. So an administrator, his job, her job, is in the nature of a surgeon, cutting it up, taking out the bad bits, sewing it back together, and sending it on its way. Has fiduciary duties as well as legal duties. Fiduciary, remember, comes from the Latin fides, meaning faith, and these are duties of good faith. As well as legal responsibilities, he also has to act openly, honestly, has to disclose full information about any transactions that he's been involved in, any profits that he makes. He mustn't make any secret, non-disclosed profits. Of course, he has to make a profit, otherwise you won't get people to do the job. Must send notice of appointment to all creditors. All business letters here, all business letters, correspondence, all has to bear this legend that says administrator appointed. Must obtain a list of creditors. You'd think that they'd do that before he sends a notice to the list of creditors. Yeah, they must obtain a list of creditors, and they must send notice to the registrar within 7 days of his appointment. So I'm not sure if the court will do this or whether it's the responsibility of the administrator. It's not onerous. People who are administrators are qualified insolvency practitioners. This must be one of the basic rules that they learn when they're qualifying as an insolvency practitioner, that they have to send notice to the registrar within 7 days of their appointment. Must require a statement of affairs. Statement of affairs is prepared by the directors, and it shows all known and contingent creditors and the book value of the debt that is owed to these people. But it also shows all assets at book value and at breakup value. It shows what is the forced sale value, and the administrator is then going to compare the overall debt with the overall asset value, both carrying value and breakup value, and see if there's any reasonable prospect that we can convert those assets into settling those debts and then carry on with the company. He prepares proposals and submits these to the court. Prepares proposals in order to show how he intends, how she intends to process the process of administration, to get the court's approval, really. And then they must manage the affairs of the company, must manage the affairs to the best of their ability. Don't forget that these are QIP, qualified insolvency practitioners, and they manage the affairs of the company in the best way to achieve the desired result, which is either putting the company back on a solid footing or disposal of the company to some interested third party to get a better resolution of the assets, or liquidate the company if that's the best way forward. Advantages of administration compared with liquidation. I think you'll probably find that these are intuitively obvious. Company can continue. It's sewing up the body corporate and sending it on its way. It's sheltered from creditors, pushing it into a liquidation situation, demanding their money. Prevented from applying for a liquidation. All liquidation applications are dismissed, pending the work of the administrator. The administrator is able to challenge previous transactions. If the directors or those in control have granted a security in respect of an existing loan to another person or to a third party or to a connected person within the appropriate time period, which I covered when we dealt with debentures, then that can be challenged. And the administrator can say, this security that you granted to your infant children in respect of a debt apparently due to them, this was created only 18 months ago. It's granting security to a connected person within 2 years. And that's not allowed. Can you explain how or why this should be allowed? Yes, because the infant child lent new money to the company out of the infant child's own trust fund, and therefore it should be allowed. Oh, okay. So the administrator can challenge transactions in order to swell the company's assets, can challenge some of the directors' actions to see whether or not directors have been misappropriating assets, taking assets at an undervalue. The administrator can challenge these and recover those assets and potentially approach the court on the basis that the directors have been acting fraudulently. Creditors are more likely to get something back. Something is better than nothing. And members will hold shares. If the company can be moved forward, the members will still have a shareholding, but now in a viable company, hopefully. Maybe, maybe not. Any creditor can apply to court. But again, the court will look seriously at the motives of the creditors applying for court. The court will say you're only doing this to push the company into a situation where they have to settle your debt. You're not going to use the court as your debt collectors. Floating charge debenture holders may appoint an administrator without approaching the court. They can't appoint a receiver, an administrative receiver, but they can appoint an administrator. Creditors will have a continuing customer. Customers will have a continuing supplier. Directors avoiding the stigma. Do you know that word? The stigma associated with having been involved in an insolvent company or a liquidated company. So lots and lots of advantages for appointing an administrator rather than for appointing a liquidator. The end of the administration period, when it's successfully completed, or when you go to court and say, I can't do it, it's not worth saving, please liquidate the company. 12 months after appointment finished, the administrator should have done it within 12 months. Application to court to finish it. Listen, I've done the best I can. I've given the reins back to the directors. Will you dismiss me from office? Or, it's not worth saving. Will you liquidate the company? Application to court by a creditor. The creditor feels that enough has been done. We're fine. We're okay. Everything seems to be all right. You're simply continuing in office to give yourself more fee income. That's unfair. So a creditor can ask on the basis that the administration is substantially complete. When the original applicant is discovered to have had an inappropriate motive, it's one that this creditor who's been owed some money and is being refused because maybe it's in dispute, maybe. So the creditor approaches the court just to cause trouble and get an administrator appointed. Well, if the court finds that out, having appointed the administrator, if the court discovers that the motive for the creditor's application was inappropriate, then the court can finish the administration and tell the administrator to come back, come out, come on, we no longer need the administration. The directors can take over again. The administrator can apply to the court on determining that it's not going to work, or it should never have been in administration, everything was fine, or the administration has been successful, that everything's fine, everything's gone according to plan, everybody's been paid off or will be paid off, the directors are back in charge. Will you dismiss me? Will you take away my responsibilities? I no longer need to go in there on a daily basis. Okay, so that's administrators.